Hi, I'm Greg Corombos. My guest at this time is Andrew C. McCarthy, former Chief Assistant U.S. Attorney in the Southern District of New York. He is now a National Review Online contributing editor and columnist, and he's a Fox News Channel contributor. We talked to him a lot through the Mueller investigation, impeachment, and now the latest legal kerfuffle here in Washington, and it deals with the recommended sentencing for former Trump confidant, I guess is one word to use for him, Roger Stone, who was convicted on a number of counts, mostly of lying to Congress a while back, and now he's facing sentencing. The initial recommendation was for 7 to 9 years. President Trump went on Twitter to protest that and say it was far too excessive, miscarriage of justice, and so forth. So the Justice Department is now lessening that recommendation, and Trump and Attorney General Bill Barr are being accused of doing political tricks here. So let's start with the very beginning here. Andy, the 7 to 9 year recommendation, you've written on this recently, and essentially you say there's a case to be made for it, but it's still excessive. Explain what you mean there.
Well, I think, Greg, the problem here, if you want to go to politicization, which is what this controversy is all about, that begins with the Muller Probe. There would be no Roger Stone case if it weren't for the Mueller Probe. That's not to say he didn't commit the crimes that he was convicted of, but he would not have been investigated if he had not been connected to Trump. What they prosecuted him for in an ordinary case would have been charged in a much more modest way. Instead, they threw, they took basically one course of obstructive behavior and turned it into 7 felony counts, which meant that when he got convicted, which because he is something of a bird brain who decided to intimidate witnesses in text messages that were there for everyone to read, it took the jury, a nanosecond to convict him, and he was then looking at 50 years incarceration, possibly under the statutes. The sentencing guidelines are, in federal law, what mainly drives a person's sentence, not the overarching statutory exposure you have. It's the guidelines. So just to be concrete about it, if a narcotics felony has a statute that says that the penalty for it is 0 to 40 years, the sentencing guidelines will tell you within that vast range where somebody should be sentenced within a narrower range of months. So in the case of Stone, even though he was looking at 50 years of statutory exposure under these various 7 obstruction counts, which included witness intimidation, his guideline sentencing range was something that was much more modest. And on one interpretation of it, it was 37 to 46 months. And on another interpretation of it, it was 90 to 108 months. And the thing that drove it from either one category to the other was an enhancement in the sentencing guidelines of what they call 8 points on the offense level for a situation where somebody accused of witness tampering threatens physical violence to the witness that is being tampered with. And in this case, there's no doubt that Stone did that. There's a lot of doubt about whether he was really serious about it. And between that and his advanced age and, the fact that this whole thing was blown out of proportion from the start, the big argument is whether that 8-point enhancement should have applied or not.
Andy, one of the things we're hearing now from the Department of Justice is that they were misled by the prosecutors in this case. And as you point out, at least a couple of them are from the original Mueller investigation. How does that happen?
Well, I think here what happened, Greg, is that this was an office. This is the Mueller investigation that the Stone case came out of. But indicting Stone was just about the last thing that Mueller did before he closed up shop and filed his report. And the case got transferred to the U.S. Attorney's Office for the District of Columbia, which, as you and I have discussed in the past, the fact that Mueller transferred these cases to components of the Justice Department underscored to me that we should never have a special counsel in the first place, because you only have a special counsel when the Justice Department can't handle the cases because of conflicts. So this case went to the U.S. Attorney's Office for the District of Columbia. That office was in transition while the Stone sentencing was being pulled together. So President Trump nominated Jesse Liu, who was the U.S. Attorney for the District of Columbia, to take a high-level job in the Treasury Department. She was kind of managing the office with one foot out the door until the end of January, when Attorney General Barr appointed a new person who was one of his close advisors, a guy named Tim Shea, to take over as acting U.S. Attorney for the District of Columbia. So while all this flux and transition is taking place, the prosecutors on the Stone case, who are basically holdovers for the most part from the Mueller investigation, are preparing for Stone's sentencing. And they didn't file, I guess they made their submission suggesting 7 to 9 years of incarceration this past Monday, which was February 10th. So the new acting U.S. attorney had just come on the job, and it's clear that there was some consultation that went on. I understand the Justice Department is now at least suggesting, but they're not saying very clearly that they were misled. The New York Times is reporting that the U.S. attorney and the Justice Department, the Deputy Attorney General, were advised what the prosecutors were planning to do and thought it was excessive, but didn't put their foot down and tell them not to do it. So it could be one of these cases where there's a complete communications breakdown. Maybe somebody lied to somebody else, but I think we'd be hearing more about that if that was really what happened. I have a sense that what happened here was there was probably some transition chaos, and this is one of those things that should have gotten a harder look, but probably fell through the cracks a little bit.
Andy, of course, part of the reaction to this story is that Trump tweeted in strong language, as he always does, about this, and the conclusion by a lot of folks is that, well, Attorney General Barr or somebody else at the Justice Department saw that tweet and jumped and then changed the recommendation for a shorter sentence. Both Barr and Trump say they haven't spoken in person, and this is a good time to point out that the Attorney General is different than other cabinet officers. In some ways, they're an advocate for what the president wants to do, but in other ways, they're much more independent than other cabinet officials. So is it proper or improper for the president to lobby the attorney general for sentencing recommendations or anything else with a specific case? Or is the bigger issue how he went about it on Twitter rather than picking up the phone or something?
Well, I think it's constitutionally permissible. You know, all executive power and prosecution is an executive responsibility in our system. All executive power belongs to the president. Most presidents prudently stay out of the day-to-day prosecution of cases because we want that to be controlled by the rule of law, not by politics. And when the president gets involved, what people say is that the system is politicized, and once it's politicized, you have to then worry about its legitimacy, and that's very important because its legitimacy underwrites our domestic peace and tranquility and prosperity. So there could be a chain reaction, which is a bad one, if the public thinks the president is politicizing prosecution. I would also point out that there could be a bad reaction if prosecution is politicized by other forces besides the president. I mean, here I think the president has a good argument that the Muller probe and the Russia investigation that it grew out of was itself politicized. So this whole thing is something of a debacle. I think it's a big mistake for the president to comment on criminal cases. That's not to say he can't do it. It's not to say that, constitutionally it's problematic. But prudentially, it's very problematic because it conveys the idea that this is all political. And in this case, Greg, it's particularly bad because I think to fair-minded people, the sentence of 7 to 9 years for Roger Stone on these facts was absurd. And a sentence of what the Justice Department ultimately guided the court toward, which is like 37 to 46 months. So we're talking about something in the neighborhood of 3 to 4 years. That's much more reasonable. So they ultimately ended at a right result. It's not like Bill Barr jumped in and made this case go away. They're still saying that this guy should get somewhere between 3 and 4 years for this felonious conduct, which to my mind is much more reasonable than the original sentence and the original preposterous sentencing memorandum, which suggested that Stone was actually part of collusion with Russia, which, that's the same failing of the original charges against him. They hinted at that, but they never charged him with it because the evidence didn't support it.
Last question, Andy, which brings us to the point of the resignation of these 4 prosecutors now. Why would they do that? Is it just about how they got to this endpoint? Do they feel like they got trumped, literally and figuratively, in terms of the sentencing recommendation here, or is it merely a political statement?
I think it's a political statement. I mean, I think this whole Stone prosecution from soup to nuts was about justifying their existence. Mueller was appointed in May of 2017. By the time that Stone was charged in early 2019, it had been well over a year that these prosecutors had to have known that there was no collusion with Russia. For them to have written the kind of indictment they wrote in the Stone case, where they, it goes on for pages and pages of, it seems like collusion, it feels like collusion, it's almost collusion, and then you get to the last page and it turns out that there's 7 process crimes. And it's because this dunderbrain texts these idiotic messages to his pal Credico, where he's talking about, do a Frank Pantangeli, invoking the Godfather movies, invoking Watergate. I mean, the whole thing sounds moronic. I'm not saying he's not guilty, but let's not turn this thing into something it wasn't, which is exactly what they did. They made it out like, there was potential collusion with Russia here, potential interference in our elections. And then when they file a sentencing memorandum, having convicted this guy of nothing remotely like collusion with Russia or interference in our elections, they went right back to the well and started to suggest all those narratives all over again in order to try to suggest to the court that this case was much more serious than it was. This case was a joke. And I'm not saying that the guy didn't do what he was charged with, and I'm not saying that some jail time is not appropriate under the circumstances, but to treat this guy like he's Al Capone when he's more close to Bozo the Clown is just ridiculous.
Andy, can't think of a better line to end this conversation on. Thanks very much for your time today.
Thanks so much.
Andy McCarthy, Chief Assistant U.S. Attorney for the Southern District of New York, National Review Online contributing editor and columnist, and he's a contributor for the Fox News Channel. I'm Greg Corombos reporting for Radio America.